Hi, everybody. Welcome to the Church Liability Protection Series. My name is Jim Abbott. I am a partner with Litchfield Cavo. I am based out of our Chicago office. I've been practicing law for over 20 years and have been defending churches and nonprofit entities for most of my career. And today I've got two very special guests, Cy McFarland and Monroe Moore, who are I can attest to from experience, are very, very knowledgeable and polished claims adjusters with the UCC Insurance Board. Our topic today is slip and fall liability. While this might not be the most exciting of topics, as you will hear a little bit later from Monroe, this is actually the most common type of claim and lawsuit that we see being brought against churches today. Why don't we kick things off by having Cy and Monroe introduce themselves?
Jim, thank you, everyone. Hello, everyone. I'm Cy McFarland. I am the Director of Claims Administration at the Insurance Board.
And I'm Monroe Moore, Senior Claims Examiner at the Insurance Board.
Cy, do you want to talk a little bit about what the UCC board does?
Yes. The Insurance Board provides an insurance program to 6 church denominations across the country. Those denominations are the United Church of Christ, the Disciples of Christ, the Alliance of Baptists, the Presbyterian Church, the Reformed Church in America, and the Evangelical Lutheran Church in America. We specialize in providing general and professional liability coverage, as well as property insurance, and we also provide workers' compensation and commercial auto insurance as well.
It's an excellent program. Thanks, Cy. I am going to have Monroe talk about some of the trends in the premises liability area, slip and falls in particular. And then when he is done, I'll talk with you folks a little bit about the types of lawsuits that we see and what can you be doing to hopefully prevent these suits from happening in the first place. Monroe?
Thanks, Jim. I thought the best way to start this presentation would be to kick off with some eye-opening facts about slip and falls. Of the general liability claims reported, 80% are slips and falls every year. Over the past 5 years, the Insurance Board has incurred losses in the amount of $6.9 million. The individuals most affected by slip and falls are over the age of 60. The top 3 states with the highest amount of slip and falls over the last 5 years are New York with 78 claims, Connecticut with 77 claims, and Illinois with 50 claims. Now, it's no coincidence that the 3 largest slip and fall states have the numbers that they do. For example, the city of New York has an ordinance that puts the responsibility of the sidewalk maintenance and snow removal on the property owner directly, the insureds. The city of Bridgeport, Connecticut's ordinance reads, "The owner or person in possession and control of land abutting a public sidewalk shall have the same duty of care with respect to the presence of ice and snow on the sidewalk towards the portion of the sidewalk abutting his property as the municipality." Even states that aren't in cold weather regions like Coral Gables, Florida, they also share the same ordinance as New York. Now, what does that mean? It's important to understand your local ordinances and what your responsibility is in that area. If the incident does happen to occur on your property and you have been taking the necessary steps to maintain the sidewalks to your city's ordinance, we will have a very strong defense if a matter is brought against your church. One thing that is important in slip and fall claims and is near and dear to my heart is late reporting. When an insured reports a claim late, it might be too late to reverse pending legal action. Timely claims reporting, therefore, is a must in these situations. Getting ahead of matters is proven to result in better outcomes and help support a partnership that is transparent and based on current information. Every day a claim goes unreported to the insurer can leave the insured vulnerable to several consequences, from denied claims to higher claim settlements. Every day a claim goes unreported, it can cost your organization thousands of dollars. Just to recap a little bit about the general liability claims, unfortunately, we cannot stop slip and falls from happening. However, there are things we can do to help stem the tide. Look at outside surveillance and lighting for your property. Make sure that you are familiar with your property's responsibility when it comes to sidewalks and parking lots. Also, make sure that when an incident does occur, that you report the claim in a timely fashion so that the insurance board can work in partnership with you to help resolve the problems at hand. We look forward to working with you on this issue, and always, if you have any questions, please feel free to contact us and we would be more than happy to assist. Now back to you, Jim.
Thanks, Monroe. I'm going to talk a little bit about the legal considerations that you should be aware of. Again, the goal is to avoid these claims and lawsuits from happening in the first place. But we want you to understand the types of theories that can be brought. That'll give you a better insight into how to prevent these actions. So take a look at this first graphic. The types of premises liability theories that are being brought: failure to make a reasonable inspection of the premises or the work being done on it, failing to properly operate, manage, and maintain the premises, failing to act on a prior complaint regarding a danger or defect on the premises, failing to warn patrons of a dangerous condition on the premises, and that could entail not having the requisite yellow tape, rope, fencing, or orange cone or warning sign regarding a slip and fall danger, failing to timely fix, repair, or correct the dangerous condition. These are the types of theories that we regularly see and have to defend against when a lawsuit is brought. The types of dangerous conditions that we frequently see in these lawsuits include potholes or depressions in a walkway or parking lot or the interior of the church, elevational differences that are greater than 2 inches, loose pavement, wet surfaces such as liquids or rainwater, unnatural accumulations of snow and ice. That can be the result of gutter drainage, a sloped surface, an incline, cracks, or potholes. A vendor or contractor's failure to adhere to the church's snow and ice removal contract. The church may, under certain circumstances, depending on their actions, may have voluntarily assumed a duty to remove the snow and ice, but if they fail to do it properly, they may find themselves in a lawsuit, whether or not there was a vendor who was adhering to the contract. We know from the snow and ice cases that, unfortunately, a bad vendor, a bad snow and ice remover entity can get the church sued as well. So it's very important to include an indemnification provision in your contract with your vendor, such that if the vendor fails to properly and timely remove snow and ice, for instance, in a church parking lot in the cold weather states, and the church also gets sued, you may then be able to protect yourselves with an indemnification position against the vendor that had been hired as an independent contractor. With respect to an unnatural accumulation of snow and ice versus a natural accumulation, that's a distinction that's important, because natural accumulations in and of themselves don't lead to lawsuits. However, an unnatural accumulation can lead to the church being held accountable. An unnatural accumulation is something that occurs as a result of a defect on the property. So again, if there's poor gutter drainage and that is causing a large puddle, and if that puddle were to freeze over and turn into a sheet of ice, somebody slips on it, that may be considered an unnatural accumulation. Issues involving the surface. Again, this is something we most commonly see with parking lots or pathways or walkways leading up to the entrance. A sloped surface, cracks in the surface, chipping concrete, potholes, things like that can cause water to accumulate. And then again, if it freezes over, little patches of ice can be created. Those would be deemed unnatural accumulations. And if somebody were to slip on that, the church will likely find itself as a defendant in a lawsuit. The vetting process with respect to a snow and ice remover should be taken very seriously, again, because it's not as simple as saying, well, we're not responsible, we hired company XYZ to handle the snow and ice removal. It doesn't work that way, unfortunately. In virtually every case where the snow and ice removal company has been named, the church is also named. Again, an indemnification provision will certainly assist, but we prefer to just make the right decision at the outset and hire a company with a very, very good track record. There are a number of owner and occupier responsibilities that you need to be aware of. Monroe touched on this already. Perhaps the most important is to provide a reasonably safe means of ingress and egress to and from the church premises. That's very, very important. That kind of goes without saying. So we want to always make sure that the walkways leading up to the church doors, stairways, handrails, everything should be code compliant. And doing a quick review of the municipal ordinance will tell you a lot. If there is any question as to whether or not these items are in compliance, then we're a quick phone call away and we can certainly help you with that. The church is also frequently responsible for abutting walkways and sidewalks and curbs, particularly if it appropriates them for its own use. And this is something that we need to be very, very leery of. Church patrons who frequently need to use an abutting sidewalk, for instance, in order to get to the church, in order to access the church, is something that the church may ultimately be responsible for. Once again, the local municipal ordinance typically speaks to that, but I can tell you, for instance, in the city of Chicago, I have dealt with this issue several times, and that includes churches. And I do recall one specific case where a woman was bringing her young son to daycare, which was at the church. And this was in the heart of the city of Chicago. And she was walking on the sidewalk that led to the pathway to the entry door of the church. there was an elevational difference. She tripped and she severely broke her leg. She fractured it in multiple places. Now, what made this case particularly interesting is that the city of Chicago was also sued, along with the city of Chicago's engineer and the contractor that they had hired that was responsible for repairing the sidewalk. Unfortunately, they did not address this particular elevational difference, and a woman was injured. She ended up suing the church as well, and the reason was, her argument, she needed to access that sidewalk, which was, of course, City of Chicago property, not church property. However, it was abutting the church property. And the case went on for quite some time. We eventually got a very good result on it, but this is the type of thing that, again, our goal is to avoid suits from happening in the first place. So if there is an abutting sidewalk or curb or municipal land that you have reason to believe church patrons and invitees need to access in order to get to the church itself, and you observe a problem such as a pothole, chipping concrete, or elevational differences, you should be contacting the municipality immediately to let them know that it needs to be fixed right away, and document your complaint. Because again, should there be a lawsuit and the church is named later on along with the municipal entity, that documentation showing that, hey, we did the right thing, we reached out to the municipal entity so that they could fix it, that is your defense, and it will be a very, very powerful defense. So abutting areas do have to be given consideration to, particularly if patrons and invitees need to access abutting areas in order to get to the church. Changing gears just a little bit, with respect to property defects, another important consideration is whether there is actual or constructive notice of the defect. Actual notice is just what it sounds like, and that would be there were prior complaints about the danger on the premises, there were prior accidents, or there was at least one prior incident, perhaps there was a prior municipal or code-related citation. If any of these things happen and the church does not immediately address the problem, and then an accident happens again, the plaintiff that is bringing the lawsuit is going to have an actual notice theory, and those are very difficult to defend because the argument, of course, from the plaintiff is going to be they actually knew about this problem and did nothing to address it. So if there is actual knowledge, it needs to be fixed, and it needs to be fixed right away. However, most of these lawsuits are brought under a constructive notice theory. And under a constructive notice theory, it is what a reasonable person knew or should have known about the property defect. So there isn't actual notice, there wasn't an actual prior complaint or incident. However, the defect was there, and a reasonable person would have noticed it and in turn would have done something about it. So for instance, if there is a spill on the floor, if there is a liquid on the church floor, and it's there for quite some time, that is likely going to be deemed constructive notice. Even if nobody went up to somebody with the church and said, hey, you should probably do something about this. Typically, the longer the defect is present, the more likely the plaintiff is going to have a viable constructive notice theory. These are all different considerations that you need to be keeping in mind with respect to how you operate, maintain, and manage your church, working closely with your maintenance team, having a good independent contractor to do snow and ice removal, seeing a known defect immediately, working with municipal employees as well with respect to abutting or neighboring property, particularly if you know that people are going to have to access it for ingress and egress purposes. These are all things that you need to be looking at, and you need to stay on top of it. Otherwise, as Monroe pointed out, you may become one of the many that ends up having to defend one of these claims. Sire Monroe, do you have any parting comments?
Yes, I have just a couple of things. A lot of our churches host or have a lot of third-party vendors that use their premises for a variety of things. And as Jim mentioned, for the larger third-party organizations, they have their own insurance policies, and it's very important, as Jim mentioned, to have a contract with an effective risk transfer clause. That way, the exposure will be transferred to the organization using the premises at that particular time. But there are a lot of our churches have third-party vendors that are smaller, and they don't have their own liability insurance policies. And it's important for those types of situations that our churches would make sure you have available a tenant and users liability insurance policy, or TULIP for short. This is a insurance policy that's really specifically designed for those smaller vendors that will use a church facility for a specific event. And those events can range from weddings to concerts, festivals, whatever situation that these vendors are using the premises. Is important to make sure that that there's adequate insurance coverage and there's adequate risk transfer, and a TULIP policy will accomplish that. So I wanted to pass along that information as well. And those policies are very inexpensive. So you're going to get the maximum liability insurance protection for that vendor and avoid the church having to bear the brunt of that exposure. And the other thing that Jim mentioned about constructive notice, we found that a lot of the slip and fall accidents that our churches experience have to do with where the floor was recently mopped and there's not a sign out there indicating such. It's very important to understand if something like occurs, the church can be held liable if someone falls. So it's important to have post signs throughout your facility if there's cleaning being done, if there's a wet area, even if situations where the lighting is not good, if there is a hallway where you have stairs and it's a dark hallway, the lights are not working, or a situation where you don't want visitors entering that section of the building. It's important to either rope those things off. If it's a doorway, close the door, post signs that say do not enter or area closed. Something to give notice to any visitor not to go in that particular area. The other thing also for parking lots, areas that are in need of repair, very important to post cones or set out cones there so that people will see, visitors will see that that is an area that is either roped off, that's an area that's not open to foot traffic. Just simple measures like that will go a long ways towards preventing these types of accidents from occurring. And if they do occur, we have better defenses on behalf of the church. Another thing in terms of snow removal is also just a log of when scheduled snow removals will occur, as well as the name of the contractor doing the work, and to make sure that that log is kept up to date. One of the first things plaintiff attorneys will look for, and that we will also look for, is evidence was there any type of written documentation showing that the area was either salted or snow was removed? And when did that occur? And if a church can provide that information, that really goes a long way towards providing an effective defense.
That's exactly right, Cy. And I would even just add, with respect to warnings, the orange cones, safety tape, a sign, things like that are all great. If there's a bigger project going on, another good idea is to actually have it in the church news bulletin in advance, letting everybody know, hey, we're about to start, this project, and here's where it's going to be taking place and how long we expect it to last. Certainly, there could even be some comments at the end of church service by the pastor or somebody with the church reminding people about that particular project. Ultimately, there are a lot of ways to warn and let people know about anything that could lead to a premises related accident. Again, we are here if you have any questions or need any counsel or advice going forward. Monroe, do you have anything to add?
Well, I think both of you have covered everything pretty thoroughly. The only thing I would stress is if you have any questions, please pick up the phone, give Cy or myself a call. We're here to help you, and don't sit on these. When somebody falls and there has been an injury, and even if they're saying that they're not going to bring any kind of suit against the church, please call us and at least talk to us about it. Don't sit on the claim.
I completely agree with that, and I would add that in addition to that, you should have the individual who was injured fill out an incident report. You should have some type of process within your church policy for doing so. That way, you're giving them an opportunity to say what happened. The nature and extent of their injury should also be addressed. We do have a number of cases where the individual did not appear to be severely injured. Maybe they complained about something relatively minor. They were offered medical treatment. They refused it, only to later find, once the lawsuit was brought, that their injury was allegedly much more serious than what they told the church when it first happened. So having that incident report is also very, very useful. I think that covers everything with respect to our general liability series slip and fall topic. Again, my name is Jim Abbott with Litchfield Cavo, and together with Cy McFarland and Monroe Moore, we thank you for your time.